So imagine this. A yacht gets zapped by lightning. The owner is adamant. It's a total loss. But the insurance company? They're not so sure. Now, this might sound like a pretty standard insurance squabble, right? But for anyone with their eyes on the bar exam, this case, Wilson Ceramics v. Pantaenius, is an absolute goldmine. It's a masterclass in how a single, seemingly small mistake can completely torpedo your entire argument. So let's get into it. It really comes down to this question. How can a few tiny holes drilled into a yacht's hull end up sinking a whole legal case? And the answer, you'll see, has nothing to do with boats and everything to do with the fundamental skills every single barrister needs to have down pat. Okay, so here is the central conflict, the heart of the dispute. On one side, you have the plaintiff, the yacht owner, saying the lightning strike basically wrote the vessel off. It's a total loss, damaged beyond any economic repair. But on the other side, you've got the defendant, the insurer, pushing back. They're saying, hang on, not so fast. It's damaged, sure, but it's absolutely repairable. The whole case hinges on the integrity of the yacht's hull. Now, to prove their point that the yacht can be fixed, the insurer needs more evidence. They want to take some more core samples from the hull to test it. But the owner says, no way. And that stalemate is what brings them to court. This leads us right to our first major hurdle, decoding the rulebook. So the insurer makes their move. They file a formal application asking the judge for a specific order. They're relying on Rule 250 of the Uniform Civil Procedure Rules, which, if granted, would force the owner to allow them to come in, inspect the yacht, and take those core samples they so desperately need. And what the judge does here is just a perfect lesson in statutory interpretation. You see, the owner's lawyer argued that the insurer had to prove the inspection was necessary. But the judge, she goes right back to the text of the rule, which is always the right place to start. Rule 250 says the court can make an order if the property is the subject of the case or if the inspection is necessary. And that little word, or, that's the whole ballgame. It means there are two different ways for the court to have power. And since the yacht is obviously the subject of the case, the first condition is met. Boom, the court has the power. End of story for part one. But here's the thing, and this is a huge lesson for any aspiring barrister. Just because the court has the power to do something doesn't mean it should. Winning the legal point on power is only half the battle. Now comes the real test, the argument about discretion. And this is where the insurer's case starts taking on water. To really get why their case fell apart, you need to know this little bit of Latin. Ipse dixit. It literally means he himself said it, and in the legal world, it's a zinger. It means an assertion that's made without any proof to back it up. It's basically the expert witness version of saying, because I said so. And let me tell you, judges do not like ipse dixit. In Australia, the gold standard for any expert evidence comes from a case called Makita versus Sprawls. And the big takeaway from Makita is this. An expert can't just show up and give their opinion. Their job, their duty, is to actually explain the reasoning behind their opinion. They have to lay out the why so that the judge isn't just taking their word for it, but can actually follow the logic and make up their own mind. In short, they have to show their work. So the insurer's entire application is riding on their expert, a naval architect named Mr. Duvall. And the big question for the court, the question that's going to decide everything, is this. Does his evidence actually meet that high bar set by Makita? All right, let's get to the main event. We know the judge has the power to grant the inspection, so now we're going to see what happens when the expert's report is put under the microscope, and why, ultimately, the judge said nope. And there you have it. The judge's finding is just brutal. The evidence of Mr. Duvall is unpersuasive. As a barrister, hearing a judge say that about your star expert witness, those are just about the worst words you can possibly hear. It's a knockout blow. So what exactly went so wrong? Well, the owner was worried that taking more core samples, which is a destructive process, could further damage the hull. The insurer's expert, Mr. Deauville, just stated that the hull could be perfectly repaired after the fact. But he never actually explained how. It was just a bare, unsubstantiated assertion. And the judge zeroes right in on this. She says, and this is a direct quote, Mr. Duvall does not explain the basis for his opinions. Get this. He actually said in his report that he'd come up with an appropriate repair protocol later on. That's just not going to fly. He was offering the conclusion based on a secret, undisclosed protocol. He completely, utterly failed the Makita test. He didn't show his work. And so, the result is a total failure for the insurer's legal team. The application is dismissed. They don't get their inspection. And think about it. They didn't lose on some arcane, complex point of law. They lost on the absolute basics. Their evidence just wasn't good enough.
So let's pull back. What are the big lessons here? What are the key things you need to take away from this case for your exams and, frankly, for your entire career?
When you're dealing with an application like this, you have to think of it as a two-stage test. It's a fundamental structure you have to get right. So stage 1 is all about power. You go to the rulebook, you read the text literally, and you ask, does the court have the authority to do what I'm asking? That's lesson number 1. But then you get to stage 2, which is about discretion. And this is where your evidence comes in. You have to persuade the judge that they should use their power. And that brings us to lesson 2. Your expert has to explain why. Their conclusion is totally worthless without the reasoning to back it up. Which, of course, leads to lesson 3. Avoid ipse dixit like the plague. A bare assertion from an expert, no matter how qualified they are, will get torn apart in court. So I'll just leave you with this thought. The next time you're prepping a case and that expert report lands on your desk, ask yourself this one simple question. Is this a roadmap that gives the judge everything they need to find their own way to my conclusion? Or is it just an opinion? Because as we just saw, the answer to that question can make all the difference.